Hi, I'm attorney Tom Lamb in North Carolina. In this Asbestos News Minute, I want to tell you about a California State Court defense verdict in a mesothelioma case involving an asbestos cigarette filter. This is not your typical asbestos lawsuit, but there are approximately 30 of these cases remaining. To this point in time, the defense has the upper hand, it seems, according to the numbers. And let me tell you a bit more about the case. Lorillard Tobacco Company produced the Kent brand cigarette from the period 1952 to 1956 with an asbestos cigarette filter. The lawsuit that we're talking about made the allegation that the use or smoking of an asbestos cigarette filter, or the cigarette with an asbestos filter, I guess more exactly, caused mesothelioma in Robert Cox. And Mr. Cox and his wife Roberta sued Lorillard together with Hollingsworth Vose, who made the asbestos filter paper that was incorporated into the Kent cigarette at issue. In late January 2010, however, a Los Angeles State Court jury returned a defense verdict in this case. The jury found that although Mr. Cox had established that he smoked Kent cigarettes during the relevant time period, 52 to 56, the defendant Lorillard was not negligent, had not failed to warn of any known danger associated with the cigarettes, and that this cigarette containing an asbestos filter did not contain a design defect. As I mentioned, they also gave a defect verdict for the company that made the asbestos filter paper itself. According to a defense lawyer for Lorillard, this is the 6th consecutive Kent filter case that his law firm has prevailed in, and that overall 19 cases have been taken to trial. There have been 15 defense verdicts, and that there are only about 30 of these cases remaining in the U.S. court system. Interestingly, the defense argued that Mr. Cox could have developed his mesothelioma from his job as an HVAC repairman, and actually here's the interesting part, brought up the secondhand exposure possibility, suggesting to the jury that Mr. Cox's father might have brought home the asbestos fibers on his clothes, and that those fibers were inhaled by Mr. Cox when he was younger, when he greeted his father upon return from his workday. The reason I say this is interesting is a lot of defendants say that, in other cases, that this secondhand exposure allegation is without merit. Here it was being asserted as a possible alternative causation by one of these defendant companies, although, again, this is a cigarette company, not your typical asbestos defendant, which tends to be asbestos product manufacturers that made pipe covering and other types of thermal insulation. For more information, visit asbestoslegalwatch.com. Thank you, and have a good day.